Comment or a reaction to my communication, I intend to move to the next item, which is inviting the stakeholders to. Yes, Honorable Secretary.
Chair, yeah, you have communicated to us that there is a big group of among our guests who are part of this bill. We wanted them to come in at once so that we can move together. So we expecting more because we may be having a plan that you are handling either 5 or 6 entities in one. So I'm seeking for your guidance, Chair, on the same.
These stakeholders they are not combined. They have their various views. They are actually separate. Let me just look at the shed we have. We have right now we should be having the Honorable Lutaya, Honorable Rachel Magola, Honorable Kiaga Hilary, and Honorable Geoffrey Kayamba. These are independent. These are independent of each other, unless you are telling us that you have one memorandum. But I presume that each of you has, because you have a forum that you lead. The Honorable Kiaga is the mover. Formerly a mover of the independent, the private mover. So all the others, except the National Culture Forum, I think they will come as a group.
Yeah, why I'm laboring to ask you that, because our guests were introducing themselves. Some are artists, one is a lawyer, and we expect those people organize those events. So, and when you, Honorable Kayamba Solo is the organizer, I don't know, because he's not an art, he's an events manager or management, he's an events management. So that's why I'm going to be well versed with the people who are with today as we move.
So we will receive them as they come.
Okay.
Mr. Chair,
yes.
Some small clarification. Are the various stakeholders, you said the various stakeholders in regard to this bill, are these the ones in their individual categories?
These were invited in their individual categories, but at the same time. However, if they have had, because they could be sharing ideas. If they have one memorandum, no problem. If they have separate, we'll receive them as separate memorandums. So probably we can now inquire from the Honorable Rachel.
Chair, the copyright bill affects all the different stakeholders in different ways, but we are all rooting for the same result, a good bill. So whether we come as individuals, it's a wealth of ideas that are coming together, which you, as the committee, we expect that you sift through what we have given you and support us to get the best. So I don't, the issue that there are different entities or not, we are all fighting for the same thing. So you shouldn't worry about it. Thank you.
Honorable Chair, yesterday we had a meeting with Honorable Geoffrey Lutaya. He communicated he would be late, but at least we had a chance to go through the principles, and together with Honorable Geoffrey Kayamba Solo, who is out of the country. So we are good to go, Honorable Chair, together with our council. Yeah.
Comfort. Don't worry about the numbers this side. Every communication that we make here is captured. The memorandums are supplied to all the members. And when it comes to consideration of the clauses as a committee, we must have quorum, which is about 15 members, because we're about a committee of about 40 members. So that time, all your views are considered. So this is just for receiving your views and interacting with you. Yes, Honorable.
Chair, why I'm so concerned, because a lot has been moving on in the music industry. So when there is such a moment, we as legislators would have to take keen interest, because there are many people who are outside affected, as the Honorable Rich has stated. So we so much concerned because there are many people who travel to Gulu, who travel to where. So we don't want to be carved into something that there is this, or we conspired with this one because they are members of parliament and they are representing their own interests. So that's why I'm so keen over that. Thank you, Chair.
You want to respond to that?
Honorable Member, by the time the bill came back to the House, there has been extensive consultation. So no one out there has not given their view if they were invited to the meetings. So this is the tail end. A few things that we feel that the Law Reform Commission probably did not bring out the way we feel it should be represented. So what you have is already representation of a countrywide consultation by the Law Reform Commission and the URSP. Thank you.
And that came also yesterday. We were told that consultations were extensive over a period of 2 years. So if there are any issues, there should be minor issues that we just need to panel beat and we have a good law. Yes.
I want to go on record. I think so. It is on.
It's on.
Mr. Chairman, can we then get the clear the clear identification of the various stakeholders and the offices they hold, such that we get them on record to see whether or not we can proceed the way we think. For instance, the Honorable Rachel Magola is the chairperson of the parliamentary. And then Madam Sarah talked about the same.
My name is Vasali Rwasuman. I come from Bujiri. But even if they don't have any capacity, in their own right, as Ugandans, because as you are aware, Parliament of Uganda did place an advert calling on Ugandans to come and appear before the committee, because there is a bill. So even if they were non-entities, even if it was a peasant from Bujiri or Bugodo, where you represent right honorable chairperson, Namayemba there, Oigemba, they are really here in their own. If they attach titles to themselves, well and good. But even if they didn't have, they are entitled to be here.
Comments, you can see now our numbers are swelling. That's very good. So, Honorable Rachel, I invite you. You'll tell us who you are, what you represent, and then you proceed to...
Chair, with your leave, I'd like to request that we start with the mover of the bill. We give him the opportunity.
Thank you very much, Chair and members of the committee. Once again, I'm Chiaga Hilary Innocent, the private mover and the Shadow Minister for Arts and Culture. Chair, to give you the background of this bill, I was granted leave on the 22nd of July 2022 to work on the private members bill on copyright and neighboring rights. A few weeks, like 2, I was contacted by the Attorney General to give this bill a holistic approach, hence the current bill today. Honorable Chair and colleagues, our original mindset intended to reward creators. We wanted not only to amend, but to reward the creators with what rightfully belonged to them, curing the infringement due to the technological advancements, attracting investors to this creative industry, identifying sources of revenue for the creators, and setting up an independent copyright management body. Furthermore, providing solutions and implementations of a structured copyright regime. In the harmonization process, Honorable Chair, we were part of the consultations, and the program was organized by the government. Whereas the current bill before you is talking about principles, some of them we agreed with them, but many of them we didn't concur with them, and that is the reason why we are before you. Honorable Rachel Magola was one of the seconders, but as well she holds and runs our forum for creatives. Mr. Mbabazi Norman is an advocate for copyright, and he has worked so tirelessly to see that this bill is amended. That's why I invited him over to have to take us through. Honorable Chair, with what we didn't agree with, permit me to briefly highlight on them and present them before this committee. Honorable Chair, in my bill, I had proposed for an independent copyright body, management body. The 2006 Act has been existing, but failure to implement the copyright law has been because of the weak system that has not been in place. So we thought we had to empower a body that could come up with the copyright management system and put up a structure that could cure and solve all the copyright related challenges that we face now. Honorable Chair, Section 40 of the current law, the Minister may, on the recommendation of the Board of Directors of the Uganda Registration Services Bureau, appoint a registrar of copyright. On B, under the same section, the Board of Directors of the Uganda Registration Services Bureau may appoint such a number of assistant registrars, copyright inspectors, and other officers as may be necessary for the efficient discharge of the duties and functions of the registrar under this Act. The assistant registrars, copyright inspectors, and other officers shall report and be subject to the direction of the registrar. Already that states that there is mandate given in that law that calls for a body, an independent body, to manage the copyright. Still under Section 41(2), it states that the registrar's office shall be the National Copyright Information Center, meaning the National Copyright Information Center has been already gazetted as a body under that Act. So the bill as proposed by government is not speaking to this, and we find it challenging, and we're going to go back to what we want to cure. So I do propose to this committee that we retain and back up with justification the need to have an independent body managing copyright, so that we realize fruits out of whatever we are doing right now. Honorable Chair, the nature of business of this entity holding the current role of registrar of copyright, URSB, is majorly to carry on registrations in the relevant laws as enshrined in the Principal Act, the Uganda Registration Services Bureau, Cap 210. Honorable Chair, the international treaties, national laws, and requirements of copyright do not necessarily require registration, but rather management and development of rights that accrue from the works that hold or create copyright. This is further evidenced by the number of copyright registrations by the URSB in comparison to its registrations with the relevant laws. That I have had the privilege of looking at the Uganda Registration Services Bureau Cap 2010 and specifically looking at Section 4 of the Act. It states that URSB will administer and give effect to the relevant laws, to provide registration services and collect and account for all revenue provided for under those laws. The first schedule of the same Act states the relevant laws, and below, if you have my my writings, they stipulate and outline the laws that URSB is answerable for. Thus, our law, the copyright law, is not therein, Honorable Chair. That I have not seen the Copyright Act Cap 2015 at the same time, which was eventually repealed by the current Copyright and Neighboring Rights Act of 2006 as one of the relevant laws that are administered by URSB per their act. So the Copyright and Neighboring Rights, Honorable Chair and members, is not part of the laws that have to be governed by URSB. Honorable Chair and colleagues, that in various countries that were benchmarked during the discussions and deliberations of the copyright laws by the stakeholders, including Ghana, Malawi, Zambia, Kenya, Nigeria, indicated that a separate copyright authority is the best practice, and as such, that was the intention at the time. This has further been reaffirmed by the international best practices, which have always advocated for an independent copyright authority or body. Honorable Chair, whichever country that we talk about where copyright is working effectively, there is a body, an independent body running this these services. But here, being under URSB, even if you went there today, it is just a desk of not even qualified people to run this. Yet we want a qualified team that is going to manage and run copyright related works. So, Honorable Chair, when it comes to the body, I retain, together with colleagues, that we need an independent body to govern and run the copyright and neighboring rights if we are to achieve what we are running right now. Another issue, Honorable Chair, was on the callback tunes. I had proposed for a revenue share because due to the technological advancements, the telecom companies, the aggregators, were rewarding artists basing on negotiations. So when we benchmarked with other countries, we thought there was need to share revenue and give percentage to who gets what. So I'm glad that we comfortably agree with the revenue share as proposed by government. However, when you look at, However, Honorable Chair, much as we are comfortable with the revenue share, it is not specific on who gets the 60%, because it is speaking to the author or performer. We would propose to adopt a Kenyan style and Nigerian format of a split sheet, where the law is clear on who gets what, than the ambiguous sharing as proposed by government in theirs. So with the collar back and ring back tunes, we concur that the revenue share is okay, but we need to be specific on who gets what, especially when it comes to the 60% as allocated. To some of the countries where we benchmarked, we saw that, for example, they are clear that the content owner or the artist gets this percentage, rather than hiding under the author, hiding under the producer. So it is not clear, which we need to cure immediately. Honorable Chair, the third one, our interest was on the collective management system. In reference to the amendment, Section 20, amending the Principal Act, Section 56. Collective management organizations play a vital role in the corporate management by acting as intermediaries between the copyright holders and users of copyrighted works. They simplify the process of licensing and royalty collection, ensuring creators are fairly compensated while making it easier for users to access and utilize creative content. In simple terms, Honorable Chair, the CMOs are the brokers in the supply chain of copyrighted works. All creators create their works to be used, seen, and utilized by the with pay. Therefore, the structuring, the management, and the empowerment of CMOs must be held as a first priority in the legal formation of Uganda, where a majority of the rights holders are still unaware of what belongs to them. Honorable Chair and colleagues, in Kenya, for example, the rights have been separated as follows. We have Music Copyright Society of Kenya. This focuses on collecting and distributing royalties to only musical works. We have the Kenya Association of Music Producers. This represents music producers and manages their rights. We have the Performers' Rights Society of Kenya, CRISKI. This manages the rights of performers, artists, musicians, etc. Then we have the Reproduction Rights Society of Kenya. This deals entirely with the production rights for various copyright works. Rather than what we have in Uganda, where all rights have been merged together with proper distinctions of what right falls where, the bundle of rights that CMOs are supposed to manage should be further explained to easily be understood by the common man, who by way is supposed to benefit from this law. The current amend seem to want to deal away with the number of people required to form a society, which in my opinion is wrong. Originally, Honorable Chair, it was 30 members of a similar right or a similar interest, which now is to be removed. It should be realized that the entire copyright industry is based on creation, pay, and usage. The cash channels could be unreachable for all the content owners, and as such, the need for empowerment, properly managed, supervised with correct personal CMOs and known sources of income for creators. Honorable Chair, the bill here seems to introduce monopoly, and monopoly has been a challenge. One of the challenges that we have one CMO dealing with musicians, for example. So whenever we have these monopoly tendencies, the manipulations, the extortions, the exploitations get on rampant. So we wanted to cure this by having a window where CMOs can emerge, provided they legally qualify. My last one, Honorable Chair, before I invite in Council Mbabazi, is on the private copy levy. I'm sorry they made a mistake on the first line, but I want to verbatively react to this. Honorable Chair, as a creator, you cannot chase for whoever is infringing and misusing your works. Everybody here has a gadget called a phone. The more the capacity of the phone, the more expensive. But the capacity in terms of what it carries is based on people's content. You find, Honorable Chair, that whoever is using a gadget, for example, the laptops in this meeting, all have music. Whenever people are bored, they play music. But the music they play is not theirs. It is other people's product. So we are like, we can't chase for Council Tamale when he's playing his music on a laptop. But we can get him somewhere. When this laptop is coming into the country, let us work with the Uganda Revenue Authority to make sure that we have a certain percentage for whatever gadget that carries people's content. We have a fund that is going to help this institution, this creative industry, such that whatever percentage that we collect from all these gadgets, we have lined up different gadgets. We have laptops, we have phones, we have flashes, we have tapes, we have CDs. All these come in the country, and a Dr. Hilderman who produced Tabitebi Kute can know who is consuming his music. It is permanently on a CD that he cannot account for. So it is my property that somebody is enjoying. I love government to cure this by giving me a percentage, by giving the entire industry a percentage, that at the point of entry we have these gadgets charged, and a small percentage charged goes and we create a fund. You know, just like we created the road fund, we can have a private levy fund that government can manage to make sure that it uses this fund to run and develop this industry, this creative industry further. Just like it used the road fund to boost the infrastructure. So if you to boost the infrastructure for the creatives, we have proposed an avenue where you can get money, where people are not going to be harmed. So, Honorable Chair, much as the government didn't propose a private copy levy, in this struggling economy, we are also introducing an avenue where government can get revenue. We are introducing an avenue where the government is not going to tap on other resources, but tap on the same resources by the creatives to have this fund run. We can confirm, Honorable Chair, that this fund can, that this industry can sustainably run its affairs if we have this fund. So, Honorable Chair and colleagues, I can justify and let you know that copyright levies should be collected and distributed as a form of compensation for the loss of sales and incentives for future production to happen and promotions. Another reason is that it is difficult and impractical for a copyright owner to enforce his or her rights in this domestic sphere. Ideally, since copyright is a private right, it is the duty of the right owners to identify cases of private copying and prosecution the same, in order to enforce their rights or get remunerated for it. In the practice, private copying is difficult to identify, Honorable Chair. It is difficult to prosecute. It is difficult to license. It is only government and through policy, which policy we are working on, that we can realize this. All attempts to enforce the copyrights, also, an attempt to enforce the rights of copyright owners by preventing private copying in the domestic sphere, especially in regards to the analog environment, is likely to interfere with the privacy of our consumers. Since this era is tedious to regulate, paying levies to the benefit of copyright owners is a way of enforcing the rights of the copyright owners. In this regard, Honorable Chair, we are not just proposing something that has not worked anywhere. This has worked in most of the countries in the European Union. This has worked in Kenya. This has worked in Nigeria. Which countries I'm mentioning, and which countries are inspirational to the Ugandan creative industry. With that, Honorable Chair, permit me to call in my friend, Council Mbabazi Norman, to submit on the remaining before I invite in Honorable Rachel. Council.
Honorable Chair, maybe to further affirm why private copying levy is very important for the creators. It's because in the current Act, Section 14, in the fair, the fair principle, where you can utilize works of other people, it makes it, the fair practice is that the person who is using work for personal use cannot be or will not infringe. But now the problem comes, the continuous sharing. If I have a gadget and I send to a group of 500 plus people, these would have been consumers or customers for that particular product. Now there is a law providing for fair use. However, it does, the same law did not put or did not anticipate excessive fair use. Someone has work, my work, got one copy, and now is distributing to thousands of people who ideally would have been users who would pay. So that is why the principle of private copying levy is introduced, to make sure that the creator also has a benefit coming into him or her purposely as a result of continuous usage of the work by unknown, unmarked people. In other platforms, for example, Spotify and others, you are able to track how many people are able to utilize your work. You are able to know how many people used your content, and as such the remuneration is known. It may be small, but you can track it. Similarly, with radio stations, you are able to know how many times a certain song was played. But now with the private sharing, which ideally you cannot interrupt with the owner of the phone, we will hardly know how many times my work has been shared, and that is loss of revenue to the creator. That is why we believe the private copying levy will cure that problem if a simple levy, very small amount, could be 0.1 or 2% on the device, collected and handed over to a fund. Because if we to be realistic, the phones over time are going to lose their original value of calling. They have become data centers. There is so much data stored on the phones, and that is being shared. Some people don't make calls. All they do is watch videos, listen to music, share a photo here and there. They don't even have numbers in those phones. They're just utilizing data and sharing information. So our target was mainly on the items that we believe will move or transmit copyrighted works, such as phones, flash disks, laptops, among others, which are what we are using in the digital era. We are not using CDs or tapes or books anymore. Everything has become digital. Someone downloads your book, and within a second, thousands of people have read your book. This book would have sold. This book could have been sold, and you'd have earned something. Mr. Chair, we are also thinking in the alternative, since there is a bit of resistance in the private copying levy, just in case you could give us a second alternative. For example, there is what we call a communication to the public license. This license is supposed to be paid by people who are communicating to the public, still excluding people who are watching my content in their homes. We're talking about people in hotels. People who own hotels go and get a single transmission from DSTV, then retransmit within the various numbers of hotels that they have, the rooms that they have. And then they are only paying a single subscription. But they have 100 rooms. Those are 100 guests. Imagine there was no DSTV in those rooms. I want to believe those hotels would be shunned. And the reason why people are going there is because of the content that we create. That content gives the hotel meaning. That content gives the bar meaning. That content gives the stadium where people are watching from or sharing my content from, it gives them meaning. The law provides for the communication to the public license as it is before in the 2006 Act. However, Uganda being a peculiar country with a lot of stubbornness and people not knowing that they actually are supposed to pay or do certain things, we would have preferred if the law came out specifically to mention which people should pay the communication to the public license for avoidance of doubt. Because very many times you will go to a hotel and say, my friend, you are communicating to the public. They will not understand. They will simply send you away, lock you out of the gate. But now if we have categoric schedules which say hotels, bars, restaurants, in Kenya, taxis and buses, if you don't have a TV, people will not come to your taxi. That TV is communicating my content. That TV is communicating content of other creators. In fact, if you're now they have gone to a second level. If your matatu doesn't have Wi-Fi, they will still not board it. So that means the reliance on content. We are only looking at the matatu, but we are forgetting what makes it pricey and what makes it desirable. It is the content. And that content has a price. Somebody somewhere invests money to make sure that content comes to life, Mr. Chairman. That content is what is being used to attract people. A classic example between, for example, a law firm, or a dentist, or an optician. If there is no TV in any of those places, and if there is no TV in a hotel, who will suffer loss? I would believe the hotel will suffer loss because it has to communicate content. The dentist doesn't care because what you come for is a service. Once your tooth or teeth have been removed, you walk out. So, Mr. Chair, I believe we need to take time to be sincere in these revenue streams for content creators and where the sources of income will come from. For example, from the radio stations, the hotels, the TV stations, the buses, the taxis. In fact, you can even help us and say, impose that levy on the buses and taxis as they come into this country. You are able to do it for us, prepare and tell us how you have, what you have achieved, and then give us what is ours, and then you can even tax that levy if you feel so, and then create more revenue for the creators. Mr. Chair, in the same vein, we are facing a very big problem in this technological advancement. The other day, UCC published and said that Ugandans spend 55 billion daily on TikTok. One platform, TikTok. And TikTok alone raises 222 trillion annually from data purchase. One platform. But what is TikTok without content? We are suggesting that within the law, we need to find a way to put these so-called big telecoms at the point where they contribute towards content creation as well as a proper payment for the creators. We are not going to find TikTok here. TikTok has no offices here. But who is here is the telecom. The telecom is the one that sells data. UCC says a GB is sold at 25,000. If you calculate how much money Ugandans spend on TikTok, WhatsApp, Instagram, YouTube, it is closer. It comes to about 38 trillion. If I'm not mistaken, that's closely a very big portion of our national budget. So, these guys are enjoying all this money and they are not bothered about the content creators. I was talking to someone as I was walking in and he said, me, I don't use, anyway, my money is not on TikTok because the content that TikTok has is not for me. And then that means if the telecoms were serious, they would now invest in the content creators to create actual content from which would move from the 9.9 subscribers to say 20 million. And then their revenue will increase, but also the actual payment of the content creators will also be realized. Mr. Chairman, still in the amendment, we see something called a reversionary interest, where we understand it came as a result of publishers where they would buy content of artists. No, it's not, but yes, but I'm just giving you, we took particular interest in some matters, but these are general, they are part of the bill. They are part of this bill. So we thought those are some of the things we could talk about as well. So there is a reversionary right that within 20 years, if you assign, the work will revert back to the owner of the work. But if I sell you my property, I've decided to sell it to you. Probably I don't even need it. Why do you force it back to me? I have sold it 20 years, and then you're saying it should come back to me. I mean, why do you think I sold it anyway? I've sold it off and I don't need it back. Probably. If I have the intention of having it back, then my agreement should state as such that I'm leasing you my content, bring it back after so many years, and this is the money that I am charging. But having it in law that 20 years later work should come back to me, I find that an interference in the law of contract. People should be able to contract freely. People should be able to relate with one another and agree on what's good for them. But I also understand what the amendment was meant to cure. We had similar issues with I think the late Kasi Ukira, how he had bought rapporteurs of so many guys and had them at ransom at that time. But the moments have moved. People are now informed. People are aware of what is theirs and what's not theirs. So I think, Mr. Chairman, some things that we saw or we see in the amendment ought to be looked at in relation with other laws. And finally, Mr. Chairman, when you look at 49A about a takedown, it requires that for me to ask for a takedown, I must have a certificate of registration. That is not the law. Copyright was hinged on non-registration. Registration is a by the way. So if you require, if I come and complain about my work being infringed upon and you want me to have a certificate, that is against the international treaties for copyright. Ideally, copyright is created once work has been created. Registration is by the way. You may need it for evidential value, but if I complain to you and I need my work taken down, probably the first thing you should do is take it down, and then we can go into ownership confirmation thereafter. Because by the time I come to you to complain about an infringement, clearly I don't think I would be an impositor to complain about my content that is being misused. Thank you, Mr. Chairman.
Thank you, Chair. I thank my colleagues for very informative presentations. I have distributed copies of recommendations that we as the Parliamentary Forum shared with the international phonographic industries. So I think they have been distributed, and for the interest of time, I'll just point out some of the key recommendations, and my colleagues have already mentioned a lot of what is in this document, so I will want to look at a few. But one thing that as a committee or as people deliberating on this bill, the technicalities and all that are great, but an understanding of the importance of this bill, we need it like breath of air. Because the resistance to some of the recommendations, especially the private copy levy, come from, we are going to increase taxes. That's what everybody is looking at. We are not looking at the benefit of the existence of the private copy levy. We all here are parents, aunties, and uncles. Our children participate in the creative economy. The private copy levy has a share to government. In most countries, it's a 60% share to government, 40% to creators. We are already battling with issues of collecting tax for development. Here is a straightforward way for government to get money into the treasury. But the resistance seems to come from those creators. When they act as if the creators are not part of the society. I know for a fact that things like the printers, the photocopier, schools use one book and print 200 or 1,000 copies for their students. The writers cannot benefit when they can only sell one book, when they could have sold 1,000. That is theft. And it's being done in government organizations, in schools, because there is no law to say we need to make sure that the creator and something. We need to remove that envy against creators, because it's one of the things that are standing in the way of creating laws that are going to support creative people. So I talk to you as members of the committee to look deep in your hearts and think, if this money comes, who does it benefit? It benefits all of us, the creators and government. And I cannot emphasize enough, without a management department for intellectual property, we can speak until cows come home. We need somebody who has an eye directly on this money-making machine. So I request that we look into that as well. At the danger of repeating what my colleagues have said, most of what I have in this document, which has got internationally accepted standards, all countries are doing what we have in the documents that we are presenting to you. So as you look through them, think about the benefit to an economy which is 70% youth and women. And these are the ones who are working in the creative economy. I'll go back a little bit and remind you, fashion is the creative economy. Painting is the creative economy. Arts and crafts, because that seems to be forgotten. Every time people speak, they speak about music. There is that mindset which is stuck in music. But there are about 21 different sectors in the creative economy that can make money if we streamline the way the creative economy is funded by government, is remunerated in terms of returns. We need to get away from the existing mindset. So this has been submitted to you. Much of what is in this document, my colleagues have already elaborated. So I beg that you use this document in addition to what my colleagues have submitted. Councillor Tamale, I always tell people, from head to toe, today, your hair, a creative person did that. Your tie, somebody did it in fashion, but the person who designed the flowers on your tie, those are two different people. Your jacket, somebody else. Your shoes, your phone. I cannot emphasize, in one day, each one person employs about 9 people every day. Multiply that and see how much money we can make if we do what I and my colleagues are saying to save the economy. Thank you.
Thank you. Honorable Rachel, Honorable Kiaga, and the council. Colleagues, you have heard the issues, the recommendations, the proposals. We can now weigh in. I will start with the Honorable Saliro.
Mr. Chairman, I want to thank you. But in a special way, permit me to thank the Honorable Hilary Kiaga and the Honorable Rachel Magola. This bill, Chair, is one of the benefits of having specialized talent in Parliament. I wish the public knew that when you have specialized people, they add value to legislation. Because we've been here, Chairman, me and you and the Honorable here, but because we didn't have the talent, these are things we are not taking very seriously about. It's just like the sports bill. When Honorable Magogo was elected MP, He came with that experience and background. And so these are the fruits of having special talent and skills in Parliament. I would want to recommend to the people of Maokota and Bugweri, yeah, to vote these people back to Parliament, because we would not be having this. And if I will come to your constituencies in my other capacity to converse, yes, as a president, I will come. And when I get iPod money, I will also give you. Yes. It's coming, I think, next week. Chair, when you look at this bill, and the reason why we really need to support the recommendations and the observations made, there is one fundamental issue that needs to be highlighted. The bill largely domesticates our obligations under international law. And I want to think that Honorable Chiaga and Honorable Rachel, that should be our strongest point. Okay? That as a country, we are signatories to a number of international treaties on the creative industry or intellectual property, and as Parliament, we have no choice but to actually domesticate them. So we would be highlighting all those provisions under international treaties and bring them in conformity with our laws. It's really as simple as that. And you know, I have told Parliament before, because we also have challenges in that house, failing to listen to knowledgeable people. I have been on the floor several times, and I've been telling my colleagues that once we have an obligation under international law, we have no choice but to ensure that that obligation is reflected in our domestic law. And I keep quoting to them the common Latin maxim under international treaty, Pacta Santa Servanda, that a country has an obligation to put in place what it has agreed under international treaty. And a country cannot hide under domestic law to circumvent its obligations under international law. And that's a debate for another day. So, for me, that's how I'm looking at this bill. Purely in terms of respecting and fulfilling our obligations under international law. Now, having said that, Mr. Chairman, I just need a clarification on a few issues. Number one, on the Honorable Hillary was talking about the current law. If you look at your presentation, it should be page 2 and 3. On page 2, you are quoting the URSB Cap 220 and looking at Section 4 of the Act. The laws to be administered under that Act. Okay? And the fear you had is that the copyright law or laws dealing with copyright are not among those that are supposed to be administered under the URSB Act. That was your observation. Maybe, and I'm not trying to undermine my next point, which I'll make on the authority, but this is very easy to cure, Mr. Chairman, because these laws that has to be administered under URSB only appear as schedules. So they can be amended anytime. The minister can amend the schedule to include laws on copyright. So that is not a very big, problem. But it does not in any way take away the need to have a copyright authority as you have proposed. But there are two issues maybe that you need to look at. One is government policy. of rationalization that is clearly moving away from statutory, authorities, bodies, commissions, and we were all in Parliament and we had this debate. Okay, I don't know how you would want this matter to be pushed in light of the existing government policy that is evidently against, creating more public institutions as a way of managing resources. Maybe that is something you would need to clarify on. Number 3, Chairman, was on the ring-back tunes. Again, for purposes of clarity, if you are saying that the performer and author should benefit from the 60%, okay? Then for purposes of clarity, you would also do good in terms of legislative clarity to propose how much do you want to go to the author, how much should go to the performer. But if you are only classifying those who are supposed, the category is supposed to receive, without providing in terms of guidance what it should be, I think it becomes a problem. So maybe for clarity, that is something you need to look at. Chair, finally, is on the issue of the private copy levy, as I'm seeing it here, copyright levy. Again, this is something you need to explain, because as you rightly observe, it will be resisted as occasioning another tax. It will be resisted. But more fundamentally, how does the content creator benefit from this fund? Does it operate like a circle that content creators will belong to that circle and will be going to pick the money? Or it is a fund that is going to enhance the development and support of the industry? Is there individual benefit that will accrue from this fund, or you are looking at collective benefit? I think it is also something you need to explain so that we're on the same page. Otherwise, Mr. Chairman, this is these recommendations should be supported in light of the fact they are coming from our own, our colleagues. It is only then that we can express solidarity. And for me, who moves many private members' bills, I am really very supportive, and I'm very happy that our colleagues had to come up with this idea. I thank you, Mr. Chairman.
Thank you, Honorable Suman. Now we have been joined by other stakeholders who will be coming in shortly after we have discharged Honorable Rachel and Honorable Kiaga. So you are just here because we needed you immediately after, but you are not part of the meeting. So don't be prejudiced by our discussion. Yeah, don't be prejudiced by our discussion. Just listen. Yeah. So I have some clarifications also to seek. The first one is on the issue of a separate agency for copyrights. We heard yesterday that URSB is going to be taking the lead as it is provided for in the bill. And you are now saying your original plan was to have a separate agency. What would you suffer? Would it be fatal if we maintained URSB with enhanced personnel Of course, the law has come in to give them most power and enforcement. Would it be fatal if we maintained URSB, considering what Honorable Suman has said? We have rationalization on our hands as a policy, and URSB has already been doing some work. How about if we just strengthen them in the bill? Would it be fatal? Number two, revenue sharing of the ringback tunes, the sharing of the revenue that comes from ringback tunes. You propose that it should be clearer. I think Honorable Suman again has alluded to that. You need to propose, that is something that we agree with. You need to propose the percentages or the ratios such that you speak in specific terms, such something that we can adopt. And then the splitting of the CMOs to avoid creating a monopoly. This one I agree with you, that CMOs should be created according to rights, in the akin to the Kenyan style. I think this is okay, and you need also to guide us on how we can do it. This is something that I think is agreeable to us. Now, the issue of private copy levy. What did you agree on with the government? Because you have been in discussion for over a period of 2 years. Now you have failed to agree and you have thrown it to us as a committee. What can we do? What did you agree? What came out from your discussions? What came out? Because yesterday I asked the same question to the Attorney General, and he said not all gadgets are designed for, not all gadgets are used for content, music and all that. Some people have their phones strictly for making calls. So for you to put a levy on a smartphone, because the presumption is that it's going to be used for copy and all that, it is being unfair to probably that percentage that is not going to use it for that purpose. So for that reason, I think they declined, but you will need to tell us what exactly did you agree on in your discussions. Then the issue of the alternative that you create, the communication to the public license, this is a very good one. You also need to tell us how far you went in your discussions and consultations, because this is a very good source of revenue. And then the telecoms and social media platforms, such that telecoms should charge $1 per subscriber. Was this canvassed in your consultations, and what came out? And then you'll need to, we have read the bill, but it's a technical bill. You'll need to help us to understand what sources of revenue have been identified for the content creators in the bill as it is. What is there for the artists as it is now? We need to know what is there before we can be able to now look around and see if we can. And then the issue of the reversionary rights, which Council speaks to. And it says this is against contract. I had the same view yesterday and asked the Attorney General. And because if it is contract, and I've decided to sell my property, although it is intellectual property which cannot be ceded, but I've decided to sell it under contract. I concur with the Council that we need to probably discuss this further to see whether it does not infringe rights of two contracting people. So those clarifications, I think I will need them. The document by Honorable Rachel is quite clear, and some of the issues are part of this. The others, we'll see what we can do about them, but they are quite clear. We thank you. So you need to respond to those clarifications. Honorable Sanja, you have something?
I have been comfortably covered by you and the other colleagues, but mine is something small. just a general feeling, because yes, it is. Several engagements have gone on between the movers and government and Attorney General, and you seem to have, whatever you have achieved, I see it is not very relative, because most of the key issues that are affecting the industry, you were unable to agree with the government, which is very, very fortunate. For the independent body, at least that one, we are aware of the policy. You reached somewhere on the issue of the ringback tons, the revenue. Then the private copy levy, but you have given us the alternative. I just want to find out, Mr. Chairman, sir, why the movers who are members of parliament and well-known artists, because when you talk about Hildeman, when you talk about Rachel Magola, the honorable members, everybody, even a local person in the village, they know your contribution to the industry. Why did the government fail to agree with you on such key matters where you are very informative and you have got the experience? We need to find out from you whether they were just falling on a deaf ear. Otherwise, we are very grateful for the contribution, and we will, Mr. Chairman, where possible, as a member on the committee, we will support them. Thank you.
Honorable Richard Oseku, anything from there? Thank you. Okay, let's have the responses and
thank you very much, members. Honorable Chair, we thank you, one, for the time and for the different concerns you have been able to notice. The question is why we failed to harmonize with government. We've been talking with the Honorable Rachel. Honorable Chair, the major objective for amending this bill is to empower the creative industry. And in the creative industry, we have players, of which even government is a player. So government has government officials. This I'll make it clear. So we have beneficiaries who have been benefiting from the situation as it has been. We failed to concur with the government because whenever we talked about issues or areas where artists are going to get money, it was a challenge. Yet for us, coming up with this amendment was to make sure that artists' revenues are raised. But all the concerns that are coming up can clearly show you that wherever we talk about areas that concern money, government is rejecting. So I know this committee processes laws, and in every bill there is that principle that runs the entire bill, much as we can have many other principles. One of them, in this case, is artists earning from their works. So, Honorable Chair, whatever we are proposing, I'll talk about the collab tunes. The telecom companies are part of the stakeholders, but from when they came into this country, they have been exploiting the musicians. We don't expect such a team to be seated. So they will collaborate with the government because they have been collaborating with the government, this I will fairly say, to continue exploiting these creators. So we are saying reducing their rates, their share to that percentage is already alarming to their institution. So you will have the fights. So, Honorable Chair, we are proposing, just like our colleagues in Tanzania, just like our colleagues in Nigeria, just like our colleagues in Kenya, they have a spreadsheet where they highlighted that an artist will get this percentage. They talk about the artist, who is the content creator. For example, if we said we are going to give the artist 60%, let us simplify it and be particular that artist will get 60%. We have the aggregator. The aggregator will get this percentage. Then we have the telecom will get this percentage. That is how other countries that we benchmarked with are doing, and that is how they came up with their law. About the URSB enhancement, yes, Honorable Chair, we are aware of the policy.
Now, on that one,
yes,
give us those percentages. For us, we are not technical in these things.
okay.
You can think through, you can send it. You can send it.
That I will do.
Give us the percentages that you want.
Okay, but on the spreadsheet, I want to have the artist, the service provider, who is the aggregator around there, and then the telecom company. Those three are enough on that spreadsheet. Just a minute. So for clarity, we shall copy from our colleagues from other countries. Then we have a challenge, Honorable Chair. If we are to have this law function, Honorable Basalirwa talked about the international treaties that we are signed to. So we are having a challenge that we are not respecting these treaties, that our domestic affairs seem to be taken away from the domestic treaties that we signed. But the domestic treaties that the international treaties that we signed and that we are signed to clearly give guidance on what we need to do if we are to realize the copyright enforcement and promotion. So unless we get rid of the international treaties that we signed or that we are signed to, then we can't realize this, because all this goes holistically with the international treaties that even government relates to. I beg to ask Honorable Rachel.
Thank you, Hilary. I mentioned earlier that it's all about will. When you have URSB, where there's not one person who knows the industry, they are put in a job which they do not understand at all. We have a problem there. Honorable mentioned it, said, when you have people who know the industry and how it works and how it benefits people in places of authority, then things can move. But most times, I remember when we came before the Finance Committee and we were talking about this last year during budget, somebody, one of the members said, never yimbi namwe twaba wa copyright butimu endachi. You can say there's a dismissal, and as long as there's a mindset of dismissal, everything we say gets resisted. So committee, we failed because the people who are in positions do not understand the value of the creative economy to the growth of this country. So as a committee, you have the mandate to tussle this out and listen to both sides and let people understand that this is useful. Without that, there will be resistance. The issue of the separate body for the URSB. URSB is under Ministry of Justice. The core function of Ministry of Justice is not dealing with copyright. So issues of the creative economy always end up at the back burner because it's a by the way. Now when we have our own administration, even if it's under justice, but when the people who run it are people who know and understand the industry and its value, we might get somewhere. Thank you. Yes, you've mentioned presidential advisor. Yes, presidential advisor does not replace technical administrative needs. So everybody can be a presidential advisor. It does not make them knowledgeable about what is required for this industry to work.
For me, we are faced with a situation like Honorable Basaliro has said, when there is a government policy in rationalization. We appreciate the situation of government, but I want to think, as the law states, let us maintain a registrar of copyright appointed by the minister
With expertise.
with expertise. It doesn't matter whether they are in fisheries or, but as long as that person is knowledgeable
Qualified.
in copyright matters. Today, we are lucky that the current Registrar General of URSB studied intellectual property at her master's. If tomorrow a certain colonel is heading URSB, what is going to happen? So let's be intentional to create a head of copyright who might sit at URSB, no problem. But this person has some bit of qualification, or even further to that, is very qualified in copyright matters with the specific practice, as well as is grounded with what's happening in the industry. You see, these people in their offices, and they are not aware of what's going on the ground. Everything they see, they meet at their desk. So I don't mind whether the Registrar of Copyright is situated within URSB, but can this person be appointed as the law requires and is qualified in that manner, separate from the Registrar General? Because tomorrow, when the Registrar General changes, and you know they have tenure 3 to 5 years, I'm not certain, what shall happen if the current head of the current head of veterinary is brought at URSB? There will be a challenge. Secondly, well, intellectual property is a practice, and there are studies. People have PhDs, people have masters, and then there are people who have practiced in this industry. There are people. You see, it's like UTB. It talks about tourism, but you don't need to be a tourist expert to head the UTB. All you need to do is someone with the skills in marketing to market the country for tourists, and that's what we are saying.
This creative industry, you'll discover that it has attracted many people who have not necessarily had gone through your formal education and qualifications. And I don't want that also to be a clash between the industry practitioners and what you would call the professionals. That's why I asked, is these qualifications, are they born out of academic journeys?
Yes.
Or experience, exposure, and expertise? You know, me and you, when we are arguing expert evidence, expertise can come either out of qualifications or
Experience.
out of experience. So maybe, Chair, for purposes of report writing and our record here, these people should be able to guide, because they will ask you on the floor whether you are an expert in this field, Chair, and you may not have an answer.
Maybe to clarify, the various institutions in different countries that have independent copyright bodies, they have people who have studied in the art of intellectual property, and particularly in copyright, and they have practiced. You see, whereas it has, we need to differentiate between a practicing artist and a technical person, because copyright is simply, the administration is mainly in licensing, collection, and distribution. How do you tariff? How do you collect? Who do you distribute to? That's the essence of copyright. I collect from the users, I give back to the creators, they create more. And that's where the technical aspect comes in. It may not necessarily mean because you are a filmmaker, you can easily go and head, you can be a registrar of copyright. No. You have to be grounded in that field as a result of academic practice and qualification.
Okay, thank you. So you have something to say?
Thank you, Chairperson. I come back to your question that really touched me, of why government has not listened and take effect in what we are asking it. Our industry is one of a messed up industry. With all the entities that we have, the top rank is the music. Probably filming now has taken really second. But if you see the branches that we as the creatives have, is huge. And because we are really scattered all over, we are like kids from one mother who disappeared, and we're trying to hold on to who can listen to our problems and give us a solution to what we need to do. But however or whichever way that it has come now, that they're maybe not listening, we are very privileged that this committee is here to listen to our problems. This is what we've been going through, and good enough, we are all adults. Your children are also going to go through the same things, who happen to create something. Just imagine if your son or your daughter is creating an animated little something, and oh my God, it's gone wild. And you think about the time they've put in and who has benefited to it. And we here today have literally done so little to help these upcoming youth that are actually in this industry big time.
Thank you.
So I think the question is why not the government why is it not helping us do it? Let's start from the behind, because now we've been trying to go to Ministry of Gender. Everywhere. This is the time now, I think, that we need to sit down and say, okay, this is what they are putting on the table. How can we make it better for the next generation to come? So whomever will be sitting in our position today, so many years to come, will say, oh, they did a fabulous job, but they left out a little bit of this.
Okay,
That is all I'm asking.
Thank you so much. That brings us to the end of our interaction with the honorable members and your staff, your team you moved with. You have left us with the sound proposals that we need to consider as a committee, the issue of a separate agency, the issue of sharing the revenues out of the callback tunes, splitting the CMOs to specific rights, the PCL issue, private copy levy. That's an issue that has not come out so well, but we will see what to do as a committee. And then the alternative, communication to the public license for those public spaces. And then the telecoms and social media platforms, the idea of $1 from per subscriber. And then the proposals in Honorable Rachel's document, which are some of which are similar to this. All these will be considered by the committee. Thank you so much for your time, and you stand discharged. Thank you. So our next team has quite a number of stakeholders. I will be inviting the team leader to come and take up this seat. And then the team leader will, yeah, karibu, you're welcome. Mkulu Tulao, team leader. Very good. Meanwhile, we have some tea here. Can grab a cup of tea. You're welcome to water. Take some water. So the meeting is called to order. We have already had a prayer. The prayer was said in the morning when we commenced our meeting. The next item is self-introductions, and I will request that we commence with the hosts, starting with the Haji Asmani Vasalira at the extreme left.
Mr. Chairman, I thank you. My name is Vasali Rasman. I come from Bujiri.
Chair, I am Oseku Richard. I come from Palisa and I'm a member of this committee.
Thank you, Chair. My name is Nsanja Patrick, MP in Tenjeru South from Kayunga District, member of this committee. Thank you.
Have our staff.
Thank you, Chair. I'm Gamusi Andrew George. I serve as a clerk on this committee.
Thank you, Chair. My name is John Tamale Mirundi. I'm a principal legal officer and the lawyer attached to the committee.
Thank you, Chair. Sheila Watua, lawyer.
Thank you, Chair. I'm Flavia Rita Babide. I'm a senior economist attached to this committee.
Thank you, Chair. I'm Emmanuel Sabwenji. I'm the personal assistant to the Honorable Chair.
That is our side. I'll now invite the leader of delegation to take us through your...
Thank you, Chair. Good morning, everyone. My name is Aragadi. I'm the chairman of the National Culture Forum.
Good morning. My name is Charles Batamze. I'm the vice chairman of the National Culture Forum.
Procedure, Chair. Yes. You know, we are dealing with the creative industry vis-a-vis Parliament and Hansard. Everything here is being recorded, it's going on Hansard. We have to present a report. So I want to propose that names be given as they appear on national IDs for purposes of the record, not the creative industry names. I thought I would create that clarification.
This is a house of record. Parliament is a house of record.
Yes.
And we as a house of record, that is correct. Please.
I will answer that. My name is Ragadi, on record. Yes.
And then Mr. Batambuze with the vice chairperson.
Okay, I was still introducing myself because I was also going to give a AKA. But anyway, Charles Batambuze is my name. I'm vice chair of the National Culture Forum. I'm also the executive director of the Uganda Reproduction Rights Organization, one of the collecting societies.
Thank you, Chair and members. Well, my name is Emmanuel Mlondo, also known as Emma Carlos. I'm the Executive Secretary for the National Culture Forum and the founding chairman for Uganda Talent Managers Association. We are the business and the professional wing of the sector. Thank you very much.
Hello, my name is Kamlegeya Suleiman, otherwise known as KS Alpha. I'm the Director, Strategic Planning, UMA, Uganda Musicians Association.
Good afternoon, everyone. My name is Geoffrey Ekongot. I am the Executive Director at the Uganda Musicians Association.
Good morning, everyone. My name is Fina. My name is Fina Mgera. I am the Vice Chairperson of the Uganda National Culture Center and the General Secretary of the Uganda Musicians Association. Pleasure to be here.
Good morning, Chair. Good afternoon, Chair. I'm Noah Nyanzi, Board Member of National Culture Forum and a visual arts practitioner and an upcoming actor.
Good afternoon, Chair. I'm Martin Okia. I'm the Chairman of Uganda Publishers Association and a body member of URO, a CMO on literary works.
Good afternoon, everybody. My name is James Wasula. I am the Executive Director of the Uganda Parliamentary Forum for Creative Industries and the Executive Director of the Afrigo Band, celebrating 50 years of existence this year.
You switch off that microphone, that one, yeah.
Good afternoon, Chair and members. I'm called Bujingo Hannington. I'm the President of the Uganda Comedians Association, and I also sit on the board of the Uganda National Culture Forum. Thank you.
Good afternoon, Chair and members. David Chibuka Kasozi is my name, and I'm the board chair of Uganda Reproduction Rights Organization. Martin is confusing me. He's always, yeah. Thank you.
Be careful, you are assisted with a comedian, so he could mess you up.
Good afternoon, members. My name is Musingus Godfrey. I am here on behalf of the National Union of Creative Performing Artists and Allied Workers. Thank you.
And my name is Stephen Baka Mugabi. I represent Bukoli County North in Bujiri. I'm the chairperson of the committee. We have, all right, you are welcome. Yeah. So, thank you. Our next item on the agenda is communication from the chairperson. I want to start by welcoming you, our stakeholders from the creative industry. I want to welcome the members once again to this meeting and thank the stakeholders for responding to our invitation. Thank you for coming. The committee has started listening to stakeholder views on the Copyright and Neighboring Rights Amendment Bill 2025. We started yesterday, and we had the movers of the bill, the Minister of Justice and Constitutional Affairs, who was represented by the Attorney General. We also heard from URSB, and then we heard from the Uganda Law Reform Commission. Those three stakeholders have been at the engine of preparing this bill in consultation with you. And so today we have continued with the exercise by listening first to the private mover, Honorable Kiyaga, who was here, Honorable Rachel Magola, and now you who are the major, I think you are the major stakeholders in my view, because you represent the various individual artists, content creators, and so we are pleased to have you here. On our side, we are thin on ground. You are more than us, but that's not a worry. We are going through very difficult times as MPs, but we decided to prioritize your business, this law, because we have been receiving so many calls from many stakeholders expressing interest in this law and asking us to pass it as soon as yesterday. You want it passed. So we decided that even if we are extremely busy, we will reserve time for this bill to be heard in the committee. We have our report ready. House has been adjourned. Signda is go home until we'll be called. But as soon as we get back, we must have our report ready to present to the House such that we pass this law before we go to the recess which takes us to the general elections. So although we are thin on ground, the views that you give us are captured, they are recorded. The memorandums you give us are also very important. And there is that time as a committee where we have to sit, where we must have quorum of at least 15 members to look into all the various views that have come up before we make our report to the House. So we are properly constituted and we welcome you. We are ready to listen to you and interact with you on the proposals that you bring to us. Now, how are we going to proceed? Because I heard that we have about 4 associations here. Do we have a single memorandum or one memorandum? Very good. Led by Mr. Ragadi. You make our work easy. So with those few remarks, unless there is a reaction to my communication, okay?
Thank you so much, Mr. Chairman. The first one is that immediate one you have asked, because our visitors introduced themselves in the various forums. I was about to ask whether they all fall under the same umbrella, the National Culture Forum. But I understand this is their report, but I see here on the first page, it is indicated that I just want to confirm whether you had any engagement with the Uganda Parliamentary Forum, which is headed by the Honorable Rachel Magola. So they did.
The executive director is right there. So
okay. I just wanted to confirm that. Thank you.
We have just commenced the process. The whole of next week will be here, and I believe CMOs are some of the stakeholders will be interacting with next week. the clerk has had. So next week, CMOs should be invited.
Just to comfort our brother, even if you are not an organization, as an individual in your own right, you can seek audience with the committee. The rules don't limit appearance before the committee to organizations and groups. Well, the parliament may identify some stakeholders, but since there was a notice in the newspapers for this interaction, which notice is out there, you can, in your own right as an individual, come before the committee and give your views. But obviously the chairperson has guided that they've been identified. But if there are people out there who think may add value, somebody could be an academician somewhere who has taken interest and you know them, you can talk to them to come and appear before the committee. Because what we want at the end of it all is to have a law that is very enriched and that will benefit all of us as a country. I thank you, Mr. Chairman.
Thank you. So whoever is out there and is interested in appearing before the committee, they are welcome. They write to the clerk, and the clerk will apportion them time to come and appear before the committee. So we can now proceed. I invite you, Mr. Chairman, NCF.
Thank you, Chair. On behalf of National Culture Forum, which is the apex body of the creative sector in Uganda, I would like to thank you for the opportunity given to us. Truly, this is the apex body where we have everything encompassed in the industry. We have film, music, and everything. We have the comedians. We have everything is in there. So for purposes of clarity, we have everyone at stake here who is the foundation of the industry. So today, even if not everyone is being invited, I think we have got the cream of the industry that will explain most of the things. We have taken this and seriously considered everyone to be part of it. Our paper looks big, but it's, we have outlined most of the important things clause by clause. And I'm going to ask Mr. Batambuze to explain clause by clause of everything that beefs up the whole meaning of our recommendations. Thank you very much.
Chairman and members of the committee, thank you for inviting us to interface with you on this critical matter of the Copyright and Neighboring Rights Amendment Bill 2025. This bill has been long in coming. We have interfaced with government as artists because we felt there was a way in which the industry needed to benefit given the changes that have happened in technology and so on. When we came in, although we were not listening to the conversation we were having with the honorable MPs, but we got a sense in which, for instance, one of the issues, does this bill really, is there something that will cause more money to get into the pockets of creatives? Because that was a concern for us as creatives within the industry. So this bill, we sat as stakeholders to analyze, and I'm pleased to take you through our thoughts on the different clauses within the bill. And we start at clause 1, but maybe a general observation. When we looked at the bill, we were a bit confused, because the bill was referring to sections in the Principal Act that are different. Actually, I wanted to ask our council at some point whether there was another act of Copyright and Neighboring Rights Act that I'm not aware of, because I was wondering how the Attorney General would not know that the sections they are referring to are wrong. So in our submission, we have referred to very many, actually most of the sections that they pick from the Principal Act are wrong in our view, because we are working with the Copyright and Neighboring Rights Act of 2006. So I wanted to make that general observation. It cuts across all the provisions within the bill.
So, Chair, I assume that they are looking at the old Act of 2006. We have a revised edition of the laws of Uganda, which came out, I think, last year in July. Yeah. So the current, the bill as it is now, is quoting actually the right sections of the law.
So the revised edition changed the section?
Yes, because under the Law Revision Act, the Law Reform Commission is given mandate to remove laws that, provisions that are spent. So in all the laws, if you look around, one section was removed, the commencement section. It is a spent section. The laws are already in place. So that section, when it was moved, the numbering also changed. So the current act that we have is it's no longer 2006, it is CAP 222. So if you are using the 2006 act, it is a wrong citation. The content might have changed here and there. But their presentation is still holds water, Chair. I don't want to discredit.
So that is not substantive?
No, it's not substantive.
Okay. If it was caught, you would have been thrown out on a PO.
Thank you, Chair, for the clarification. Of course, for us, we are just industry practitioners. Yeah, we don't follow.
It's good you had not consulted your lawyer. would have faulted him.
Yes, we don't follow the changes in government. For us, even I looked for that act, the one you are referring to. I checked the Ministry of Justice website, and it was not there. So I had to work with the 2006. But all the same, I think the changes are minor. Okay, we begin at clause 1, which is on definitions. We looked at all the definitions and we are in agreement with the definitions provided. However, we feel that the definition of orphan works requires more clarification. And the clarification we want is to add on the definition that is there, the statement after diligent search conducted in accordance with the regulations prescribed by the minister, so that the definition reads, orphan works means works protected by copyright whose author or copyright owner cannot be identified or located after diligent search. Just qualifying that a work qualifies after, to be orphan after a search. Yeah, just that. Then I'll quickly move to clause 5. Clause 5 is amending section 13 of now CAP 222. It is introducing a new section 5B, which makes contract registration mandatory. This is page 2. Contract registration mandatory by rendering unregistered contracts voidable after 60 days. While registration enhances, obviously that while registration enhances enforceability, automatic voidability creates legal uncertainty. It penalizes parties even in undisputed cooperative arrangements and may be exploited for strategic termination. This discourages investment, it undermines digital licensing practices, and risks fueling piracy by making unregulated contracts unenforceable. The thing is, we operate in a digital environment as creatives, and most times when we go online, for instance, to upload content for purposes of monetization, the contracts there, all that we do is click yes or no, and when you click yes, the contract is signed. So one of the concerns is, if we must register contracts, it would mean we would have to probably download those contracts, then register them. But remember, we are operating in a fast-moving, and every day we are creating. Imagine a TikToker that creates content every other day. If they must, for every work that you have uploaded, register that contract that is digital, it becomes cumbersome. So we are proposing that we retain, because in the current law, registration is not provided for. So we are proposing that this provision be deleted. And to ensure, this is so that we can ensure that works enjoy full protection without unnecessary formalities, allowing for voluntary contract registration. If you want to register, registration should be voluntary. I think even in the current Copyright Act, registration of contracts is voluntary. 2, to safeguard the full property rights of rights holders and prevent loopholes that could be exploited by third parties through piracy. Our understanding of voidable contracts is that, okay, even if it has not been registered, you can still, it still applies between the two parties, but not to a third party. And we believe that can be a loophole for piracy, because somebody will know that Batambuza has not signed a contract with, or registered a contract with the, that he signed with the Ragadi, so they can take advantage of that to exploit the work. By the time you wake up, you have lost a lot of money, and you cannot enforce. So we don't want to create loopholes. Whereas we are seeking protection from the law again should not push us in a corner where we are unable to enjoy the full benefits of our works. Chair, I want to ask our counsel here, he also had an extra explanation on that issue.
Thank you, Chairperson, and thank you, Mr. Batambuze. There are about 2 issues that concern the requirement to register contracts. First of all, is the whole principle of the subject of copyright. That copyright occurs where it's created. And the aspect of formalization is quite sensitive in the whole aspect of copyright. Whenever you talk about formalizing copyright, then that means that you're going contrary to the principles. So, yes.
Registration of the copyright?
Yes.